For those of you who have joined us and saw my face flash, you'll see that I've been having tech problems, which we've just managed to fix. You'll see that I'm joined by two guests who I will introduce in a moment. This is the 22nd of my Arbitration Bootcamp webinar series. You can watch sessions 1 to 21 on YouTube. And after this session, you will receive a list of the previous topics if you're interested in joining in. And you'll also get a recording of this session. So for those of you joining for the first time, I'll introduce myself. I'm Lisa Munro. I'm a partner at Learners. I'm a roster arbitrator at Arbitration Place. I conduct these webinars once a month, and I'm also a writer and editor for Arbitration Matters, which is a blog website that provides summaries of case law with commentary on arbitration issues as they're released across the country. So today I've got the Q&A box open. If you have any questions, I will take a look at the Q&A box and I will try to have our speakers address them immediately. And if we can't get to them, we'll review them at the end. I promise I will get you out by 1 p.m. as I always do. And as I said, you'll have an opportunity to ask questions. I'd like to introduce our guest speakers today. The first is Earl Cherniak, who is my partner and longtime mentor, a very onerous job. He is a very experienced arbitrator and commercial litigation counsel, and he's had experience both as sole arbitrator and arbitrator on a panel. And it's that experience that's obviously relevant to the topic today. Then Tina Cicchetti, who is a widely recognized arbitrator, particularly within international arbitration practice, and she has significant experience in tribunal work as well. Most importantly, I think for our purposes, that she's living the life we all dream about. She's living in Florence. And you can't see that from her backdrop at the moment, but she's definitely living the life. So welcome, Earl. Welcome, Tina. Let's dive into this. I think everybody's interested in knowing what goes on in the background when the tribunal is out of the hearing room. And of course, what's happening there is a mystery to counsel and clients who are involved in arbitration. So let's start with you, Tina. What goes on when you consider tribunal dynamics? What goes on behind the scenes that we would like to know about?
Yeah, I mean, I think, Lisa, we should start this not at the moment that you leave the room, but at the moment when you're deciding to choose the people that you've chosen on your tribunal. So when you have a 3-person tribunal, usually that's a situation where the parties thought it would be better to have 3 heads rather than 1. But of course, that only works well if your tribunal members work well as a team and actually all contribute to the decision-making process. So I think it's really important when you're selecting your chair in particular to have a view on a wider skill set than you might necessarily want in even a sole arbitrator, but certainly your co-arbitrators. And what I mean by that is you want your chair to not only be, someone who is familiar with the subject matter, who's going to have the right experience and do a good job in deciding the dispute, but also somebody who is a good leader, someone who can organize the process, someone who can keep the parties moving and on time. But sort of one of the, I think, most important soft skills that a chair needs to have is to be a good people person and be able to ensure that everybody feels and actually is heard. So you have someone who invites the contributions of the co-arbitrators, somebody who makes sure that the process is one that everybody contributes to so that it is both fair and seen to be fair. So you want to maximize the engagement of those co-arbitrators in a way that is productive. And you want the tone to be set. So you want to have a bit of an eye to the personalities of the people that you're putting together to work together. And you might even want to give some thought, due diligence to whether those people have worked together before, gather what information you know about their styles, decision-making styles and working styles, and think about that carefully before you choose someone. Yeah, go ahead.
My sense is that the role of the chair is actually very important. Not to suggest that the others are not important, but the role of the chair, as you've suggested, is to kind of organize the process and make sure that every arbitrator is contributing, and so that those personality issues, if they arise, could affect the ability of the tribunal members to work together, and that's the job of the chair to kind of overcome that. Is that right?
Yeah, I think that's right. I mean, most tribunal members that get chosen are typically lawyers and typically dispute lawyers. So, we're familiar with disputes. We're familiar with people who have different points of view. I think a lot of that sort of natural putting forward your view is not really something that you're concerned about, but it's the taking it in, trying to see whether you can reach a consensus, but probably most importantly, when there's somebody who has a different view, have somebody who is sort of humble enough to be able to take on board that view and see whether there's a way that, test it, whether it's a better approach, but at least make sure that it's one that is addressed in the reasons, in the decision-making, in the questions that are put to the parties. So it is a bit of a management type role, and making sure that everybody gives you their best and continues to be involved in the process, because that's how you get the best decision made. Is it?
I think many counsels say that they have had an experience, or their client has had an experience in which they think one of the tribunal members is not objective. And whether that is true or not, that is a perception that you hear about. Not that uncommonly. So if there is a concern that the chair shares, how does the chair go about making sure that all of the members of the tribunal are, first of all, maintaining their duty of independence and impartiality, and actually showing that in the hearing room?
Yeah, I mean, I think it's a little bit of leading by example, and also being able to problem solve as you come along the way. I mean, often if a party has that perception, the other tribunal members might share that perception as well. It's not, I think, something where one person in the room only has that view. So you want to be proactive about making sure people understand what their roles are. But of course, usually you're dealing with very experienced people who should know that. So it's a little bit about managing people's tendencies and sort of seeing where that's coming from. So there's a couple of different things in there that come to mind. One is just, if you appoint somebody who really loved being counsel and just can't help themselves from asking cross-examination questions or getting into areas just because of interest or because they think that they can do a better job than counsel is doing. That's one type of behavior that can be seen as, potentially being biased by at least one of the parties in the room. And that, I think, behavior needs a slightly different approach than, somebody who might be seen as taking the view of the party that has appointed them. And one of the things I'll say about that is I've had some really good experiences lately where I have been on tribunals that have been appointed in a slightly different way than what is traditional. So the traditional that I'm referring to is each party appoints one co-arbitrator, and those two co-arbitrators, maybe with consultation with the parties, choose a chair. Has works pretty well most of the time. But I had a couple of cases recently where all three tribunal members were appointed at the same time by the parties, or were informed of their appointment by the institution, even if the parties had done that appointment process. And what I have to say is it eliminates even the possible perception that one of the parties, one of the arbitrators has, a bias or a leaning toward the party that appointed them, because you don't know who appointed you. It's been a blind process. So that's really interesting too.
Yeah. So you say one of the ways the chair deals with this issue that is this appearance of bias is leading by example. But what if the chair has to deliberately address that issue with one of the arbitrators? How does that get done?
Well, I mean, it depends on the circumstances. I mean, you want to be discreet about it. But it is definitely the chair's role, because the ultimate responsibility is to ensure that the proceedings are fair, actually fair, and seen to be fair. So if someone is misbehaving on the tribunal in a way that potentially undermines the enforceability of an eventual award, you have to do something about it. I mean, and what you do really depends on what your skills are, who the people are, what their personalities are. But I would probably tend to do that with the tribunal behind closed doors, and not in front of the parties necessarily. I have proposed a break at times where I felt uncomfortable with the way things were going, to give an opportunity to sort of speak outside the room.
And can I assume that whatever communications you're having with the tribunal member about whom you've got concerns take place in the presence of all members of the tribunal? There's no side conversations happening. Is that right?
Yeah, I mean, luckily I've not had to do this often, but yes, it is so something that happens with everybody there, all three tribunals.
Earl, let's talk about the party appointees whom you have called the wing nuts. I often hear them referred to as the wing persons. And when you raised it in our call, we kind of had a chuckle about it. So how does the choice of those people affect what happens behind the scenes?
First of all, Lisa, I want to just supplement the topic that Tina talked about, because she talked about the duties of the chair and the choice of the chair. What is counsel, and I appeared as counsel a lot of arbitrations as well as arbitrator, but when counsel are appointing their party appointee, first of all, they want to make sure that the person that they're appointing is a qualified person, knows something about the area and the like. But what is very important, and that some counsel don't necessarily appreciate, is that the person they appoint, and at that point they won't likely know, they won't even know what the name of the chair is, but they want to appoint somebody that is going to be known to the chair, and whose views, because of his or her experience and reputation, will be considered by the chair. If you appoint somebody who is completely will be completely unknown to the likely chair, or who will exhibit some kind of a bias that will turn off both the other nominee and the chair, you're making a huge mistake. So you've got to be careful in your choice of a chair. You want to get, I mean, your choice of party nominee. You want to get somebody highly qualified, but you also want to get somebody whose opinion is likely to be known to, a new opinion and reputation is likely to be known to and appreciated by the chair.
Can I just ask a question, Earl?
I'm sorry?
Can I just ask you a question, a follow-up question?
Sure.
So
I'm
it
happy to
sounds
talk
to
about your
me,
wing nuts, but I think that's something that is sometimes overlooked by parties appointing party nominees.
yeah. So I think the point you're making, if I've got it, is that you've got the parties have chosen a tribunal of three because they want the input and the decision making of three people. And you are suggesting that if there is someone who is appointed who doesn't have the respect of at least the chair, there is a risk that their views will not be taken into consideration, or that their views they will be in a not a great position to advocate their views to the rest of the tribunal. Is that what you're suggesting?
Well, and especially if the other party's nominee is somebody who the chair will know or know by reputation, and will have some confidence in that person's experience and knowledge, as opposed to the other party nominee that doesn't have that reputation. So, there's a danger. I mean, it depends on the facts and everything else, but there's a real danger if you don't have a careful choice of the party nominee. The choice of the chair is very important, but the choice of the party nominee is also very important.
Tina.
So, I don't know about wingnuts.
Earl, Tina has
Earl.
something to say, so let's just.
Just on the choice of the co-arbitrators, if I can just add another thing that's really important. This is for co-chairs and co-arbitrators, but availability. If you're choosing a co-arbitrator because you know that person and you kind of think that they're going to be respected by the chair and the other panel members and work together and do a good job for you, if they have 150 cases, it doesn't matter how good they are. They're not going to be able to do that job for you. So you want to be careful not to be, choosing necessarily the same people over and over again who are have their book of work filled. You want to make sure that whoever you're choosing, and this goes for the chair as well, because otherwise you get delays, someone who has availability and who is responsive when the chair is seeking input.
You mean during deliberations, you don't want one party nominee slowing down the process of deliberations. That doesn't serve the party's interests at all, and it is a huge inconvenience then for the other tribunal members.
Yeah, so I mean, there's deliberations for the award, but it's also throughout the proceedings.
Yeah. Sorry, Earl, I interrupted you.
Okay, so I mean, it is rare, but it does occasionally occur that one of the nominees, and you talked about this briefly, that one of the nominees exhibits a real bias, either at the hearing itself or in the discussions between the panel members, and that's a very serious issue for the chair. And I agree with what Tina said, that it must be addressed, and usually must be addressed between all three panel members, and there can be an obligation on the other panel member, the other party appointee, to maybe complain's the wrong word, but to bring it to the attention of the chair that one panel, that the other panel member doesn't seem to be considering this in this case in the way that he or she should. But and occasionally the problem is with the chair herself or himself, and that can happen with any kind of appointee. But it could happen, for instance, if the chair chosen is a former Superior Court judge who's never worked in a group like Court of Appeal judges have, and is used to running the courtroom on their own, and has never taken the time after retiring from the bench to familiarize themselves with just how arbitrations work as opposed to trials work, because we all know, those of us who've been doing it for years, that it's a very different exercise. A properly run arbitration panel is a very different exercise than a Superior Court trial. But there are some former judges, and there's some counsel who think that they should really be running things, and they don't pay much attention to the party appointees. And in that case, it's up to the party appointees to have a frank discussion with the chair to say, this is not how it works. And so it's so in those dynamics. I mean, this whole program is what takes place outside dealing with the parties, and those discussions occur, and I've been involved in them in one way or another. And it's very important that the panel members all know what their obligations are when hearing an arbitration with a three-person panel. Very different than a trial before a Superior Court judge. And it's very different than an appeal.
Yeah, Earl, you've raised two issues. So the first is there is a concern about the appearance of bias or advocating a particular position by a party appointee. And the second is a concern about the chair somehow demonstrating that advocacy. And you've talked about dealing with both issues delicately. Help me with that. I mean, how do you really approach somebody and say, particularly a chair, we're concerned about your conduct? That's essentially what you're raising.
Well, first of all, just look at from the party appointment point of view. If you appoint someone who is likely or may well exhibit a bias in favor of the position of the party that appointed him or her, irrespective of the merits of the case, the chair and the other party are not going to take kindly to that. But if there is a situation within the, I must say, I've never really experienced this, but I've experienced arbitrations when I've been chair, when I've been a party appointee with some pretty strong personalities, but I've never experienced frank bias on the part of another panel member when I was chair or when I was a panel member. But if that happened, I think there's an obligation on the chair to deal with it privately, but to deal with it forcefully, because that's just not on. I mean, we all know that somebody's going to lose in an arbitration, and whoever loses doesn't like it. In most cases, there's not an appeal. So what the parties do when they lose and they don't like it, they go to the internet and they start searching for all kinds of evidence on the three panel members that might demonstrate some kind of bias or non-disclosure that nobody knew about before. I mean that happens in any serious case where one party loses. So so it's very important when you're appointing a chair and when you're appointing party members that they're not going to find anything when the losers start searching, because they will start searching, guaranteed.
Does this issue or should this issue have any bearing on how the work gets distributed among the tribunal members when they're starting to draft the award?
If you're asking me?
Sure.
Okay, so in my experience, there's two different ways that it happens. Occasionally, and I think most commonly, especially in fairly short arbitrations, the chair drafts an opinion. I mean, he or she will have a discussion with the three panel members, with the other panel members after the hearing is ended. And they'll talk about the issues and the like, but the chair will commonly draft an opinion and send it to the two others for comments, and comments are always received, and amendments are made, and if the panel is unanimous, that's the way it goes. Occasionally, and this is also a common experience with me in a complex arbitration where there's lots of issues, and you've got a collegial panel member that gets along and in the discussions agrees generally on the result. The chair, with the agreement of the others, will assign different aspects of the opinion to the other panel members, and then they will get together and agree on each other's draft and turn it into a final. I mean, in a complex arbitration, in my experience, a chair will, as the arbitration goes along, draft the first several pages that sets out the party, sets out the issues, sets out the undisputed facts and the like, so that when that is done, when the panel members come to actually decide the case, all that needs to, I shouldn't say all, what needs to be done is to decide the various issues that that are set out, and you know, because most panel members, most chairs want to get their reasons out within 45 days or 2 months, because that's what the parties want and expect, and the way that's done is by doing the preliminary parts, the undisputed parts in advance, and most chairs do that.
Tina, do you have any comments on this?
I mean, I also have similar experiences to Earl, where the chair will prepare at least the background sections of the award. It is typically my practice to do those initial sections in advance, as well as draft a list of issues or questions. That in preparing that part of the draft, I have sort of identified, if the parties hadn't set them out explicitly already, I've sort of identified as the issues that we're going to need to decide, so as to sort of focus the time at the hearing on the things that we think are important, you know, but then also ask the co-arbitrators if they see other issues, if they have anything to contribute, etc. I usually don't like drafting the dispositive sections, or even starting to draft the dispositive sections until the tribunal has deliberated after the hearing and I have a sense of whether there is a consensus on the views. And if so, then you sort of, I've seen different practices. I usually take the pen. If it's a big monster of an award with numerous issues, I've also, you know, taken the pen when I was a co-arbitrator to help draft different sections. So it just depends on kind of the case as to whether you have one drafter or multiple drafters. I think you have to be careful if you have multiple drafters to make sure that then, you know, someone goes back and sort of cleans it up. Because I have seen sort of, you know, in the context of my role as ICC court member, where we scrutinize awards, sometimes awards, you know, can suffer from a lack of clarity. And it's quite clear that there were multiple drafters who maybe didn't have a harmonization process that goes through afterwards. So, you know, you just have to be careful if you have lots of people contributing, if they have different writing styles in particular, or don't, you know, sort of adhere to the conventions that have been set out earlier on. It can create confusion. But yeah, it's either chair drafts or multi-draft, but the chair usually keeps control of that process.
I agree with that. You don't want an award that's obviously written by 3 different people. But you know, I've certainly been involved in tribunals where we all agree on the result, and it's a 50 or 60 page reasons or more, and different panel members draft different sections. But it's certainly up to the entire panel, but certainly up to the chair to then edit it in such a way that it looks like an award by the panel.
Tell me about how that discussion goes, because you've both talked about having a meeting of the tribunal members after the evidence goes in, and probably after the argument, to get a sense of whether there's consensus on issues or not, and then somebody takes a pen. But in the intervening time between the end of the hearing and before somebody takes up the pen, what happens? If you have a meeting, it sounds to me like there's an expectation that each of the tribunal members is going to do a significant amount of independent work in order to reach a conclusion that can then be shared with the other members of the tribunal and discussed. Is that right?
No, I mean, that's not my experience. My experience is that, you know, and it depends whether you've got a tribunal that everybody is sitting in their own home in their own screen, and it's all virtual, or a situation where the tribunal members have sat together, either in a full in-person hearing or in a virtual hearing, but it's possible to have all 3 panel members in the same room with a big screen where you're discussing what's going on in a general way before and during the breaks and after the hearing. You know, my experience is that and if I was chair, I would ensure this, that immediately after the hearing, certainly the next day, that the panel members meet and, give some preliminary indication as to where they are and whether there is going to be an agreement on the disposition of the various issues and a discussion as to how the drafting is going to occur. Is the chair going to do an initial draft of all the issues that everybody can comment on? Or is it the kind of case where there are discrete issues that individual panel members can write on? I mean, I was in arbitration recently where the latter was what happened. There were discrete issues, and the panel members who agreed on the result wrote initial drafts in those areas, and the chair and the panel together collated them into a final award. So, it depends on the circumstances, but, it's up to the chair to make sure that this is done in a timely way for a whole bunch of reasons.
Tina?
I agree with your characterization, Lisa. Like, there is an expectation that all 3 tribunal members will arrive for the first day of the hearing, whether they are in person or virtual, having prepared. I mean, the vast majority, I mean, even 100% of the cases that I do these days are on a memorial type procedure. So you have in advance, not just bare bones pleadings, but actual cases and written argument and witness statements and documentary evidence and expert reports. And you have all of the direct evidence and all of the response from the respondent side, such that you can get a handle on what the issues are going to be before you even arrive to the hearing room. So yeah, there absolutely is an expectation that the tribunal members will have done that work and will not have decided the case, but have formed a view about some of the issues, so that when you get there and you're in, hearing witnesses and cross-examination, because that's all you're going to get, and argument, you can dig down in those places where you might still have a doubt, or you're looking for more explanation, or you don't know if there are things in the record that are relevant that you haven't been able to find on your own, etc. So you're arriving hot. You should have a hot bench. And then if you are in the same room together, often the deliberation process happens organically as you're hearing things, not formally, I would say, but there's often you'll hear a witness and then the tribunal will go to coffee or to lunch, and there'll be a little bit of, how do you think that's going? Or that doesn't really, fit with what the other guy said. Like, how does that fit with the report or the witness statement? You have sort of those first impressions of the as it happens evidence along the way. You're not deliberating per se, but starting to sort of form a view on the reliability of the evidence, I would say, as it's being tested. And then I would say what Earl has said in terms of setting aside time immediately after the hearing, that has become, I would say, best practice. In pretty much every case I have lately, you have at least a half day, if not a dedicated day, for the tribunal to sit together before everybody goes back to where they came from and stops thinking about this case, to actually talk about, what they've heard over the last number of days, and start to sketch out, what could be the way forward. You have those initial impressions, and sometimes it writes exactly the way everybody agrees it should write, and sometimes it doesn't. And then, that's a more iterative process as you start to go along and exchange drafts.
I was going to say, I've had the experience where I change my mind a number of times as I'm writing it, because the analysis, maybe that's what you're talking about, it doesn't write. What seemed to make sense in my head when I start to write it down doesn't flow. Is that what you're talking about? So then the tribunal will talk about that issue, I'm assuming.
Yes.
So Tina, I've got a question for you, because I think you've done more of these virtual hearings over the past few years than I have. I mean, I know what happens when the panel members are all together during the hearings, because it's impossible not to at least talk about what's going on during the day, whether, some of the, I mean, we all make notes, not just of the evidence, but of our impressions of the witnesses or the arguments. Yeah, but it's impossible for the panel members not to have some discussion, especially if they know each other well. But what happens when all the panel members are virtual and not in the same room? Is it your experience that the panel members spend some time at the end of the day after the hearing on their own room and discussing, or do they just wait until the next day and have no dynamics in the meantime? What's your experience?
Yeah, I have not had a merits hearing with a 3-member tribunal that has been hybrid or remote. But I've had procedural hearings and substantive procedural hearings where a substantive decision had to be made, which is a little bit different. So we're not sort of discussing witness evidence, but in those cases, we keep the tribunal on after the parties are done, and go into a breakout room and have a live discussion about what we've just heard, and basically the same sort of process. What do we think the answer is?
Is that by design?
I was a panel member in an arbitration recently, in about a couple of weeks. It was all virtual. All the evidence was virtual. The lawyers had their witnesses in their own separate offices, and the witnesses gave evidence virtually. But we were able to arrange that the panel members sat together in a boardroom with a big screen, and we're all watching the same thing. And we could talk in the breaks, and we could talk before the hearing started and after the hearing started, and just, some of it had nothing to do with the arbitration, but we could talk about what was happening and what, if anything, we wanted from the party. So it was a very inconvenient way to do a virtual arbitration. But that doesn't happen all the time, especially when you're in international arbitration and people are in different jurisdictions.
That's definitely. And I did have a case where we thought we might have to be remote, and the tribunal did say, even if we get to that situation where we can't all be together at the same time, the tribunal would travel to be together. I think part of that too is if you are dealing with time zones, it can be really hard. So it is helpful to have at least the tribunal all in the same place.
It sure is. It makes a huge difference. I've done it both ways, and it's much better if we're all together.
Interesting. I'm reminded as I listen to the work that you are both talking about. It has been said more than once, or I've heard it more than once, that the cost of a tribunal is often 5 times the cost of a single sole arbitrator, and that's because you've got 3 arbitrators doing their work, and then they're talking to one another. And it sounds like your description of what occurs, it sounds like it's fair to expect that your costs are going to be greater than 3 times that of a sole arbitrator.
Hopefully it's only 3 acts.
Okay.
I mean, if you have a panel of 3, it's not only more costly, but it's much harder to arrange scheduling.
Right.
When you've got the parties on the one hand and their witnesses and 3 arbitrators. I mean, it does cause delays, undoubtedly. I mean, a single arbitrator is much more efficient in scheduling.
It seems to be that another issue that arises in this discussion is dissents. So we've got all of the arbitrators preparing in advance, and there are discussions about what the ultimate award will look like on each issue. And we know the chair's job is to try to hear everybody and make sure that all tribunal members are heard and their views expressed and considered. What is the view of tribunal members about dissents? Are they to be avoided? Is the view really that you want all arbitrators to express their views? Is there a view that there needs to be some persuasion by the other 2 tribunal members? If one tribunal member it looks like he or she will dissent, how does that work? How do the discussions work, and what's the theoretical idea behind what you're trying to achieve? Earl, do you want to start?
Yeah, sure. I mean, you don't know that there's going to be a dissent in the ordinary case until you get to the point of actually discussing the disposition. In my experience, dissents are rare, especially where you have a chair who knows how to create reasons that incorporate the sometimes differing views of the three panel members, but come to the same conclusion. So it's panel members may get to the same result by sometimes a vastly different method, or sometimes a different method, and a chair can incorporate, make sure that those considerations are incorporated in the final award. So there's not really a dissent, but there are different ways to get to the same result. But occasionally, sometimes on the result itself, or sometimes on a particularly important issue, and this is particularly important when there is some kind of an appeal route, a panel member may have a different view on a significant issue, or even on the result. In my experience, in those cases, if two panel members are agreed and the other one disagrees, the dissent should not be 30 pages. The dissent should be 2 pages, explaining why he or she cannot agree with the result of the other two, and in a pretty succinct way. That may not be the case if there is a direct right of appeal, and the dissenting panel member feels strongly about his or her view. It may be that in that case the panel member will want to write a more fulsome dissent, because he or she knows it will go to a court. Early in my career, I was in one case where I was a panel member, and it was a long hearing, and the other panel member was a former Court of Appeal judge, and about 2 days after the hearing finished, he came up with reasons for the result. Without any discussion among the panel member, the former Court of Appeal judge just wrote reasons. And I didn't agree with them, and I was appalled that happened, and I dissented. And the chair agreed with him, but I dissented, and because I just didn't think that's the way a panel should decide things. And that's a very rare occasion.
Tina?
I had one occasions where I was a panel member, the two panel members agreed on the result, and the chair dissented. It happens.
I agree with Earl that dissents are rare. And I think they should be rare. I mean, I think 20 years ago, we often talked about whether you should ever have a dissent in a commercial arbitration. You're not creating a precedent. This is not an exercise in any sort of flexing of ego. You're there to decide the dispute between the parties. And normally, there isn't a huge divergence of views after you've heard all of the evidence, after you've seen all of the arguments. It might be able to go one way or another, or there might be, different paths to get to a result, which is, I think, what Earl was talking about there. And I do think if you have an effective chair, they find a way to incorporate the views and get a unanimous result. Usually that doesn't take a lot of work. It is a rare case where you would have somebody who's on the outside, but often I think that happens when somebody feels like they've been marginalized in the deliberation process and haven't been able to contribute their views and don't feel like they've been heard, and it hasn't been incorporated in a way that explains things to the parties, which I think is a pity, because you need to be able to have those reasons be persuasive to the party who lost. And so the dissenter is, the one expressing those views. You should be able to address them in a way that is persuasive in the award, and hopefully you do it in a way that wins the dissenter over too. But if not, you at least have done a better job of explaining the rationale of the majority to the parties. And I think in the occasions when you see a long dissent, I think that's a sign of a dysfunctional tribunal.
I mean, in many cases, when that happens, it's a failure of the chair. I mean, it could be just that you've just got a wingnut as a panel member, but but if you see that it's often a failure of the chair to encourage the collegiality and the discussion that will come up with reasons that can satisfy everybody.
I've heard it said that dissents improve the reasoning of the majority because they highlight issues that the majority may not have addressed or may not have addressed adequately. Have you seen situations in which the tribunal was headed toward a dissent and then managed to persuade the other two members of the tribunal to draft the award differently in a way that got all three members unanimous?
That's the chair's job, in my view.
Okay. It seems to me there's a tension which shouldn't arise if, as you say, Earl, the chair is doing his or her job between the duty of the arbitrator to make a decision based on his or her analysis, and do so independently, including independently of the other tribunal members, I would suggest.
Now, a very difficult situation is when there's a difference on credit when significant issues turn on credibility.
Oh,
And sometimes there can be a disagreement on credibility.
have you had that experience, Tina?
Yeah, it comes up maybe more often even in my practice, in the sense that I'm often seeing international parties and international witnesses. And so you have cultural differences in the way people present, and you can have situations where somebody is perceived as being less credible because they have particular mannerisms that are inconsistent with credibility given your upbringing and legal system. So I think you have to be really careful of that. In particular in an intercultural context, even a gender context, that can be an issue. People who just give evidence differently. Often in a commercial dispute, you've got documents, right? It's really rare that you're just doing a one party said, the other party said kind of situation where credibility, there's no independent means to test the credibility. So, typically you have contemporaneous documents that support one side's credibility or not. Where you, I think, have to be a little bit careful for that with that is when, somebody sees that there's potential litigation down the road and crafts the contemporaneous correspondence to sort of support a particular view. So you just always have to be, I think, very careful.
I did an arbitration not long ago where the entire, and it was a significant arbitration, a long-running arbitration, but ultimately the decision turned on credibility of one of the principal witnesses on one side, and in that case, the panel members all agreed. But it could have been different.
We have a few minutes left. I don't have any questions in the Q&A box. So if anybody has any questions, please do put them in and we'll answer them in a moment. But any final thoughts, Earl?
Well, final thoughts. I mean,
You've already given them?
We didn't talk about some of these ethical issues, but I mean, there have been situations where panel members have gone off and done some of their own research. Because we can all do between Wikipedia and now AI, it's not hard to do. And sometimes people do it, and it's just not on. I mean, we panel members, like courts, have to decide the issues before them on the evidence that the parties put before them, because the parties know their case and they know what they want, and it's just not on. But sometimes it's hard to resist.
Tina, final thoughts?
Just say be careful and do your due. Like, it's really important. Your choice of your tribunal is important, and don't forget that you're not just choosing 3 individuals, you're choosing 3 individuals that you need to work together in a functional way. And so use the resources available to you. If you have, ways of speaking with colleagues who have direct experience with people, if you can see people in action, that's ideal. But try to get a sense or know about, potential personality conflicts that already exist before you put people together to work together, if they're known, or just try to create the most functional group of people you can.
My last thought is going to be a question to you, Tina, because it's something that I thought was intriguing when we prepared for this session, and that is be careful of outside influences, so not part of the evidence. And you talked about, for example, what if you have an unsavory witness and you've got to separate the witness from the case? Do you have anything to say about that?
I think every decision maker has to be incredibly rigorous about checking themselves for unconscious bias. And, it's unconscious, so that's hard. But and it's hard because we're trained to trust our instincts to a certain extent. So you're going to react a certain way as a human with a set of experiences to certain weaknesses in certain ways. But I think it's really, really, really important to sort of take the facts as sterile, what as horrific as they may be, and make sure that your decision is based on the facts and not an icky feeling you might have, or a sense that somebody is unsavory or doesn't deserve to win.
And is there anything counsel can do?
Lisa, let me just give an example of that in a non-arbitration context. In the human rights cases, in the charter cases, some of the most important advances, good advances in charter rights and human rights, have been in cases where the winning plaintiff or party is a particularly unsavory and unhappy character, but has a good case.
Yeah. Tina, is there anything you think counsel can do? You've got a witness like that usually before the hearing starts, and you want to ensure that the arbitrators are listening to the evidence and focusing on the issues in the case rather than the concerns that you as counsel have about your witness. Anything come to mind? I'm springing this on you, of course, at the last minute.
I guess that as counsel, like, don't sugarcoat, don't assume that the tribunal doesn't know or see that. But just do the very best you can through your argument and the facts that you've got to show that your party should win anyway. And, you might have to remind the tribunal explicitly if you have a very extreme case where you're concerned about that. It might not hurt.
Well, thanks both. I actually think we've got lots more room.
You've actually
I've got a question here. It's just popped up. Let me just read it. You're a side member, and you and the other side member have appointed a chair. It's apparent in panel meetings and pre-hearing meetings with counsel that the chair isn't as organized and invested in managing the tribunal as she should be. How would you recommend dealing with this dynamic? So you're a party appointee. Tina, do you want to start?
I was hoping Earl would start on that.
Earl?
Well, I mean, I hope that wouldn't happen, but I suppose in a really drastic case, I think the 2 panel members, if they can't get the chair to address the issues and set up the arbitration, the 2 panel members could, in a drastic case, I've never seen this happen, but I think I would recommend that the panel members write the parties and say, we're not, this panel isn't functioning properly. It's not functioning efficiently, and the party should know that.
Wow. Tina?
It's a pretty drastic remedy, but
Yeah.
I think you'd have to do, because it's up to the panel members just as much as the chair to ensure an orderly, fair, and timely hearing.
But I think that's going nuclear.
Yeah.
That is extreme, and I would hope that wouldn't arise, but I think before you got to that point, there were a few things that you at least need to try. I'm usually the chair, so I hope I'm never that person. But the few times I have been co-arbitrator, like, everybody's got a different working style, and we all know these lawyers and these types who are a little bit procrastinators or only do sort of what's on fire. One hopes that, you know, nobody who's on this call or nobody who you appoint will fit into that category. But if you have one of those personalities in your chair and your co-arbitrators, you need to figure out how to make that work, right? So you can set your issues on fire so that the chair starts paying attention to them before you go to the parties and say that it's not working. I think you have to sort of try to move it forward. And, you know, I have, you know, drafted an email that says, you know, the parties asked about whatever on this date, and, you know, I've been giving it some thought, but I was hoping to have some direction, you know, from the chair before sharing my views. You know, let me know if you'd like to send that first, or if you want me to let you know what I'm thinking.
And what about helping the chair get organized? That seems fair to me. It depends.
I don't know how you do. I mean, I have not had the situation, so I mean, I don't have any practical advice from experience in doing that. But, you know, you do, in your selection of chairs, we started out this discussion with, you want somebody who has administrative skills as well as good legal skills, good decision-making skills, good people skills. But that administrative thing is key, like somebody who can get their stuff done and done on a you know, timely manner. I mean, I've had the opposite happen too, where I've had a chair that I feel is almost too responsive, you know, where I'm getting stuff all the time, all through the weekend and all in the evenings, like immediate responses on everything that comes in, which, you know, it is not necessarily a bad thing, but that can be overwhelming too. Sometimes you have to find that happy medium and wait for the couple of submissions to come in and deal with them at once, rather than, you know, dealing with everything that comes in.
And I've had this situation. I've been on a case where the chair, for one reason or another, doesn't have any real backup. He or she is just really working on her own, and me, I'm still working. I'm an arbitrator, but I'm working with a major law firm behind me. And even as a panel member, me and my assistant have assumed the administrative burden of keeping everything together and doing all the drafts and the like. So, you know, so it can be up to a panel member to make sure that the chair has the administrative backup that he or she needs when he or she doesn't have it on her own.
Thank you. I'm going to cut it off right now because I'm at risk of being in breach of my promise to get everybody out by 1. I want to thank you, Earl and Tina. You've given me a lot to think about, and I assume our viewers as well. Our next arbitration boot camp will be February the 20th. And I'm going to surprise you about what it's about because I wanted to give you a little bit more information. As I said, you're going to get a recording of this and a list of the previous arbitration boot camps. Thanks for watching, and have a great day.
Thanks, Lisa. Thanks, everyone.
Thank you.